Hello friends, in the series on the income tax cases, today we will discuss a case which is based on section 148 notices and consequential assessments under section 147. It has been seen that section 148 notices are issued very casually in spite of a number of the judgments which say that to assess under section 147 is a very potent power and that power cannot be used very lightly. The crux of the various judgments of the various courts is that if assessing officer receives any information from any source, then before issuing the notice and at the time of recording the reasons, the assessing officer should at least make some basic inquiry that whether on the basis of that information actually the reason to believe can be made that the income of the assessee has escaped assessment, meaning thereby that the assessing officer has to make at least some very basic homework before issuing the notice under section 148. The present case is also a classical case where the assessing officer issued the notice just on the basis of the borrowed satisfaction. The issue before the Honorable Court was that whether the notice issued without any homework or without any independent inquiry by the learned assessing officer is justified or not. This matter has been taken up Honorable Delhi High Court in the case of Well Trans Logistic India Private Limited versus Additional Commissioner of Income Tax and others, and this case is reported in 474 ITR at page number 131. The date of the judgment is 2nd September 2024 and the assessment year is 11/12. The learned assessing officer received information from the DDIT investigation that there are huge cash deposits into the bank account of the assessee, and when this information was received, the assessing officer treated that information synonym to truth and without making any inquiry issued notice to the assessee under section 147 by making a belief that the income of the assessee has escaped assessment. The assessee objected to this notice and reasons and gave its detailed reply that all these cash deposited is a part and parcel of the nature of the business of the assessee and it is already becoming the part of income of the assessee. But the learned assessing officer, without going into the integrities of the nature of the business of the assessee, rejected the objection. That is why the assessee filed the writ petition. When this matter was heard by Honorable Delhi High Court by relying on the judgment of Income Tax Officer versus Lakhwani Mewal Das, which is 1976 judgment and which is reported in 103 ITR at page number 437, held that the power for assessment or reassessment under section 147 is a potent power and cannot be exercised lightly. The court said that the power under section 147 is to be exercised or invoked, not casually and mechanically. The court said that formation to believe that income has actually escaped assessment is the heart of the provision. The court said that the reason to believe should be based on tangible material and this should be evident from reading of the reasons, and in the present case there is no live link or nexus between the material and the reason to believe, and hence the notice under section 148 is liable to be quashed. The court said that in the present case it is very clear that the information which has been received by the learned assessing officer has been accepted as gospel truth and there is no independent inquiry by the learned assessing officer before issuing the notice. So the formation to believe that the income has escaped assessment, that test has not been satisfied in the present case, and moreover in the present case the plea of the assessee that the reasons are undated, and that is why it is also not clear that whether the reasons have been recorded before issue of the notice or after that is also not clear. So in the present facts and circumstances, the notice under section 148 is liable to be quashed. At the end of this video, once again I am repeating the name of the case. The name of the case is Well-Trans Logistic India Private Limited versus Additional Commissioner of Income Tax, and this case is reported in 474 ITR at page number 131, and the date of the judgment is 2nd September 2024. Thank you, friends.